5, 4, 3, 2, 1. Start. This matter arises out of a dispute concerning the ownership and continued possession of a parcel of immovable property situated within the territorial jurisdiction of the relevant civil forum. The petitioner, having claimed lawful possession for an uninterrupted duration exceeding 2 decades, seeks a declaratory relief in the nature of confirmation of title, supported by consistent occupation, maintenance, and open enjoyment of the said property. The respondent, on the other hand, contends that the possession of the petitioner, though acknowledged, was permissive in nature and granted merely as a gesture of goodwill, devoid of any transfer of legal interest. The trial forum, after appreciating the oral and documentary evidence adduced, found in favor of the petitioner, holding that the possession was continuous, exclusive, and hostile to the interest of the respondent, thereby satisfying the legal ingredients necessary for a declaration of ownership by long possession. The first appellate forum, however, took a contrary view, relying primarily on the absence of any written communication evidencing hostile intent on the part of the petitioner. The present petition challenges the judgment of the appellate forum on grounds of procedural irregularity, misapplication of legal principles, and non-consideration of material evidence. The primary contention advanced on behalf of the petitioner is that the appellate forum acted without jurisdiction in reversing well-reasoned findings of fact recorded by the trial forum without assigning cogent reasons. It is further submitted that the appellate forum erred in requiring a documentary assertion of adverse claim when the law recognizes implied hostility through conduct and circumstances. The respondent submits that the findings of the appellate forum are in accordance with law and do not warrant interference. It is argued that permissive possession cannot ripen into ownership merely by lapse of time, and that the burden of establishing the intent to possess as owner was not satisfactorily discharged by the petitioner. Emphasis is laid on the conduct of the petitioner in neither paying property tax in their own name nor undertaking any structural modifications indicative of ownership. Having heard learned counsel for both sides and perused the record, this forum is of the considered view that the appellate forum failed to apply the correct legal test while adjudicating the nature of possession. It is a settled position that mere silence on the part of the true owner does not negate the assertion of ownership by the possessor if such assertion is otherwise manifest and unequivocal. Continuous possession, coupled with open use of the property to the exclusion of others, creates a presumption of ownership which must be rebutted with clear and convincing evidence. The trial forum had rightly relied upon testimonies of multiple witnesses who consistently deposed to the effect that the petitioner had been residing on the said property, cultivating the adjoining land, paying utility charges, and preventing trespassers from entering the premises. The photographs, utility records, and local revenue entries corroborated this position. The appellate forum, in overturning the trial court's judgment, appears to have reappreciated the evidence without highlighting any perversity or material illegality, which is impermissible in law. It is also noteworthy that the respondent did not initiate any proceedings for eviction or recovery of possession during the entire period in question, despite having knowledge of the petitioner's occupation. Passive acquiescence over an extended duration lends credence to the petitioner's claim and weakens the plea of permissive occupation. Furthermore, the refusal to accept notices or respond to communications from local authorities regarding the property reflects an absence of intent to assert ownership. The reliance placed by the respondent on the absence of written communication is misplaced. It is well established that in matters concerning possession, especially in informal arrangements, conduct assumes greater significance than documentation. In rural and semi-urban contexts, where transactions may be informal, courts are required to adopt a pragmatic approach and evaluate the totality of circumstances rather than insist upon strict documentary proof. This forum also takes judicial notice of the fact that revenue records, while not conclusive, are indicative of possession and are relevant for determining the character thereof. In the present case, the mutation entries reflect continued occupation in the name of the petitioner, with no objections raised by the respondent or their predecessor in interest. On the question of limitation, it is submitted that the cause of action for the respondent, if any, arose decades ago and is now barred by lapse of time. In the absence of any acknowledgement of ownership or recognition of superior title by the petitioner during this period, the claim for recovery of possession is clearly hit by the bar of limitation. It is axiomatic that the law does not assist those who sleep over their rights. Accordingly, this forum is satisfied that the judgment of the appellate forum is unsustainable in law and liable to be set aside. The findings recorded by the trial forum are well-reasoned, supported by evidence, and do not suffer from any infirmity warranting interference. The petitioner is entitled to confirmation of title by way of long and settled possession, having fulfilled the legal criteria applicable to such claims. In light of the above observations, the petition is allowed. The judgment and order passed by the appellate forum are hereby quashed and set aside. The judgment and decree of the trial forum are restored. The petitioner shall be recorded as the lawful owner in the relevant municipal and revenue records within a period of 90 days from the date of this order. The concerned authority is directed to ensure compliance with this order and make the requisite entries in official registers. All pending applications stand disposed of. There shall be no order as to costs. Before parting, this forum reiterates that while the right to property is no longer a fundamental right, it remains a valuable constitutional right and must be respected. Prolonged possession, especially when unopposed and accompanied by overt acts of ownership, ought not to be dismissed without due consideration. The record is to be consigned to the appropriate repository after necessary compliance. Stop.